start the meeting. We'll have Dr. Wesson do the invocation. It's purely voluntary if you want to participate.
Heavenly Father, in our hearts we plan our course, but we pray that you establish our steps. I pray that we seek you for advice. Let us not make decisions based upon what we know, but let us make decisions from your wisdom. Please guide us, Lord. We place this meeting in your hands. We place our hearts and our minds in your hands, in that you may direct us. Amen.
Amen. Roll call.
Yes, sir. Commissioner Suji Rajaram.
Yes.
Commissioner Lori Hine. Present. Commissioner Nora Castañeda. Present. Dr. Gary Wesson.
Here.
Dr. Ray Callis. Vice Chair Tom Butler.
Here.
Chairman Rick Figueroa.
Here.
You have a quorum.
Thank you, ma'am. I take a motion on the absence of Dr. Callis because he can't take the calendar, look at the calendar very
Make a
well.
motion to excuse his absence.
All in favor, say aye.
Aye.
So we'll go to public comment, Commissioners. Item C, we're accepting public comments in writing and in person. Commissioners, we've received, I think, a total of 3 public comments, I'm sorry. Is there anyone wishing to address the commission on the matter that is not in the agenda? If you have here for a contested case or rule, you will be called up when we get to that item on the agenda. If you want to speak, please fill out public comment forms in the area right over there. And we'll go with Michael Montaña first.
Good morning, Commissioners.
Mr. Montaña, give me a second. I'm going to read some instructions to you.
Sure.
Okay? It says, thank you for being here. Please say your name and who you represent. You have 3 minutes to speak. Please understand the commissioners are not allowed to ask any questions or engage in discussion with you with anything that is not specifically on our agenda. Please also understand the commissioners cannot hear any information about a pending complaint or enforcement case because it may ultimately be the decision maker in the case. Do you understand, Mr. Montaña?
Yes, sir.
Okay, go ahead.
Thank you, Mr. Chairman. Good morning, Commissioners. I would like to start by thanking you for your time today as well as the opportunity to be heard. I prepared a detailed written statement that I would like to present. My name is Michael A. Montoya, and I appear before you today on behalf of Team Combat League. Team Combat League is a unique professional boxing organization which presents weekly events where male and female boxers compete across a series of weight classes. Unlike traditional boxing, each boxer on a team's roster competes in either 1 or 2 rounds, which are 3 minutes each within a tournament format. Winning and losing any given event is determined based on overall team performance as opposed to any one individual boxer's performance. As Team Combat prepares to enter its 2nd season, they intend to have 3 Texas-based teams participate, 1 in Dallas, 1 in Houston, and 1 in San Antonio. Title 16, Part 4, Chapter 61, Section 61.47, Subsection 4 of the Texas Administrative Code presently provides mandatory rest. All contestants shall receive a mandatory rest period calculated as 3 days of rest for each round, fought with no less than a 7-day mandatory minimum rest period. Section 61.107, subsection E of that code goes on to provide contests between females shall have no more than 2-minute rounds with 1-minute rest periods between rounds. We respectfully propose revision to these rules which maintain the mandatory 3-day rest period for each round fought while accommodating Team Combat League's 3-minute round tournament format and reducing the 7-day minimum rest period by a single day down to 6 days. So from 7 down to 6 is what we're asking. The proposed revision will facilitate the scheduling of a team-oriented professional boxing event in the state of Texas over the course of a season, provide economic opportunity for a roster of 24 boxers in each of 3 different cities spread throughout Texas, eliminate the gender bias of prohibiting female boxers from competing in 3-minute rounds when their female mixed martial arts counterparts can compete in 5-minute rounds while maintaining the safety of the athletes. We respectfully request assignment of this matter to the Combative Sports Advisory Board for consideration. We are prepared to provide the board with any information they require. This will include correspondence prepared by an experienced association of ringside physicians, certified medical practitioner, confirming his opinion that Team Combat League's proposed schedule and tournament format present no additional risk to boxers given the corresponding limitations on their participation at a maximum of 2 rounds per weekly event. Thank you for your consideration of this matter.
Mr. Dwyer, thank you so much. We appreciate your insight on this and your efforts on this, okay?
Thank you for your time.
All right, have a great day. Ronnie Lewis. Mr. Lewis, did you understand the instructions I told Mr. Employee?
Yes, I do.
Okay, you got 3 minutes. Go ahead.
Thank you. My name is Ronnie Lewis, and I'm here on behalf of myself. I'm here today speaking about an issue that's recently been plaguing my community. Here in recent years, I found myself towed not once but twice by tow companies. And Chapter 86 of the Texas Administrative Code says towing companies should operate with honesty, trustworthiness, and integrity. But each and every time that I've asked these companies why they've towed me, they've said things that I won't say on this mic, but it's extremely rude and inappropriate, and they pretty much tell you, pay up or shut up. And they dare you to fight to get your money back. And I can tell you, each and every time they've towed my car, I've taken them to court, I've proven there was no probable cause, but it continues to happen to not just myself, but others within my community. And I'm calling upon TDLR, the commissioner, someone to help us in combating this, because I don't have the time to take off of work to go pay a couple $100 to get my car back, and then take off of work again and go fall for a tow hearing, and then take off of work again to attend the tow hearing, when they could have just been upfront and honest and reviewed the tow up front. And I previously spoke about this issue at the 9/13/23 TDLR advisory meeting, and I've heard nothing since then about what can be done. There's a pending complaint. I've heard from no one. And I just want to know, at what point do we take action and help the people in these working class communities who are constantly plagued by their cars being removed for no reason whatsoever, and then they have to scrape up money to get their car back, and if they don't have the money, you know, that's a financial stress and burden. You have to have your car to go to work, and if you can't go to work, you're just out, and it's happening over and over. And if I've gone through so many hurdles, I can only imagine what the other people beside me, next to me, or across the state of Texas are going through. So I'm just really want to know, with the utmost respect, what can be done to not only help me, but my neighbors and the constituents of Texas. And that's pretty much all I'm here to talk about.
All right, Mr. Lewis, I know the commissioners would have a lot to say to you, but we can't. So what I would ask you to do is follow up with the staff, and I'll make sure, Mr. Francis, if you don't mind having somebody follow up, Mr.
Not at
Lewis.
all, Mr. Chairman. We'll make sure that John Medlock and Todd Forrester speaks to him after this meeting, okay?
Before you leave, will you mind getting with him? That'd be great.
I
And we'll follow up with him.
If I'm not here at the end of the meeting, because I got to make it back to Dallas, because got to work.
They'll speak to you on this break then. They'll
All right,
catch you on the
thank
break.
Thank you, Mr. Lewis.
Thank you.
Thank you. Mr. Villarreal. Sir, did you understand the instructions I gave?
Yes, sir.
Okay, go ahead.
Good morning, committee. My name is Luis Villarreal. I'm representing myself. I'm coming on behalf of the sport of boxing. 2 topics that I would like to have addressed and looked at. One is matchmaking for professional fights. Most other states have a license. You have to have a licensed matchmaker for a promoter to put on a show or an event to make accurately safe and even fights. And number 2 would be the topic of THC marijuana testing for boxers. There's been issues with like big promoters. Bob Arum has spoke about this with Top Rank, and a lot of the athletes are coming from California where it's legal, or where those commissions do not test for that substance. Rather, they test for performance enhancing substances like, you know, steroids and stuff of that nature. As a former professional fighter, I would rather be more concerned if my opponent is being tested for enhancing drugs, rather than, you know, a luxury of marijuana or whatever they're doing on their own time. That's not going to help them in any way with the fight. Not only that, but it causes Texas money with big promoters coming over here and bringing their athletes here to perform as world superstars, world champions. So in addition to that, going back to the matchmaking, I think that most states like Nevada, California, and New York require, these are big states, they're all part of the ABC, as Texas is, to have a professional matchmaker and not have you know, guys coming off the street with no experience and getting put into fights they shouldn't be in. And I think, that, anybody have any questions? Do I need to elaborate a little bit more?
Well, thank you for your information, your input, and we'll follow up with you. And if you
Okay.
have any, we'll make sure the staff, if you have any questions, definitely follow up with you on that, okay?
Okay, guys, thank you.
Thank you. Mr. Blankenship. Mr. Blankenship, you understand the rules that we?
Yes,
spoke
sir.
earlier? Okay,
Yes,
go
sir.
ahead.
Good morning. My name is Trevor Blankenship. I've been in the air conditioning field since I was 14 years old, and I'm now 34. Other than serving in the intelligence community and serving my community as a volunteer firefighter, air conditioning is pretty much all I know. But within about the past 5-6 years, sorry, a little nervous in public speaking, so I apologize. About the past 5 or 6 years, I've been fighting TDLR left and right, and it's the enforcement division. The enforcement division has had anything from agents calling me, threatening to meet up and fight with me, to accusations just out of this world that I couldn't even come up off the cuff. It's a little ridiculous. I've had attorneys get involved. I've had my family, who consists of attorneys, get involved. And I've done pretty much everything I know to do. And this was kind of my last ditch effort to see what I can do. Now, to give you a little bit of background, a little context, years back, I had gotten my license suspended. And truth be told, I did try to do some side work. Financially, it was burdened. Enforcement called me. I told them, yeah, I did do it. And I was in the wrong. Never had a complaint. In fact, quite the opposite. In fact, the people that I did offer some service for actually came to my defense and told the enforcement division how I saved them from being screwed over by major companies that most of us in this room know, which happens to people every single day, which is disgusting. However, I was in the wrong. I've tried to make it right ever since. But every time I talk to TDLR, it's somebody else's fault. It's somebody else knows something. Oh, you'll have to contact this person. You'll have to contact that person. No one ever has the information. And it goes out year or two at a time. I won't hear anything from anybody in enforcement for literally 2 years. And all of a sudden, I'll get a knock on the door from someone trying to serve me papers for a permanent injunction to revoke my license indefinitely, where I can no longer work at all. I've told TDLR that all I would like to do, pay the fine, move on, let me retest to reattain my tackle so I can move forward. TDLR makes their money and everybody's happy. But every time I've offered that, which seems very fair, I've never asked for a reduction in the fines, anything, it's been told, I don't know if we can do that. I'm not really sure if we can do that. We'll let you know.
Mr. Blankenship, is this a pending case? Mr. Jennings,
I'm not sure.
do you have a pending case in front of us?
It's not. It's all been from what TDLR has told me. It's been closed. They just want me to pay for it. So again, this is kind of the issue.
I'm saying that I'm gonna give you your time back, but I just wanna
Yeah.
make sure you can't speak to us about a pending case. So if it's a pending case, I have to stop.
It is?
If
Right.
it's already been disposed of, then
Right.
it's fine.
Right, and that's why I'm not trying to go into details or anything.
Mr. Chairman,
Basically,
can you hold on 1 second, please?
Yes. Hang on, Mr. Blankenship.
Yes, sir. Director of Enforcement Ron Foster just let me know there is a pending case.
Okay. So I have to, and again, I understand these can be confusing, but a lot of people- we can't hear what you're talking about right now because we'll be, so I apologize for that, but you can't.
Yeah.
So you'll have an opportunity to speak your case as the case plays through. So there'll be a process for you, but we
I've
can't make
tried.
public comment. I can't hear the case here
Right.
now. Does it make sense?
No,
So
totally,
You'll
totally.
have an opportunity. So I'm not sure if you want to just hold your fire until that happens, or if there's another comment that you'd like to make outside of that issue.
so yes, and again, I'm not here to argue my side or anything like that. What I basically was coming to you guys about was the lack of communication, the lack of even, how you said, a right to defend my side or even state my case. It's never happened. And I've tried and tried and tried, and I'm at the point, I don't know what to do. I mean,
Well,
so.
let me do this for you. I know it took your time and energy to get down here.
Right.
Okay? And we as commissioners, we represent the people, and it's important. we wanna make sure you understand the process and when you will have an opportunity to voice your case, okay?
Right.
So, but this isn't it.
Okay.
This isn't the opportunity. So we'll make sure staff, can you make sure, Doug, or Brian?
Absolutely, absolutely.
We'll make sure you hear the process, understand it, and then you'll be able to come back and before us and be able to articulate exactly what you want to talk to, okay?
Okay. I guess my question would be then, is there any possible way that I could maybe meet with somebody today from
Yes, sir.
general counsel or
Yes, sir.
something
I'll
to
make
kind
sure
of
that happens today. I
get
know
the
you're
ball
trying,
rolling?
everybody's, so can we make that happen today?
Absolutely.
Okay, thank you.
Thank
Mr.
you.
Blankenship.
Thank you.
Have a good day. Mr. Brian? Brian? Roberts? Brian, okay. Brian, did you understand the information I gave the other individuals, about 30 minutes for the case that were here?
Yes.
Okay.
Hi, my name is Robert Bryan. I'm I'm the founder of Karate Combat. For the members of the public that are unaware, Karate Combat is one of the fastest growing sports leagues worldwide. We're currently the top striking league in the world. We've had over 40 events to date. Despite the fact that we've only been around for 7 years, the sport is broadcast in over 100 countries worldwide. We have over 1.5 million TV viewers per event, over 20 million online viewers per event. And the reason I'm here for public comment today is we're looking to bring the sport to Texas for the first time. And in conjunction with our promoter's license, we're also looking for an admission of our fighting apparatus to the formal MMA licensing commission here, the sports division, and we want to submit that for public comment. So essentially, our fighting apparatus differs from what you've seen before with a ring or a cage. It's a depressed surface that's square with angled walls. We believe that it offers no safety issues. Other apparatuses that are different from a ring or cage have been approved in Texas before, essentially the World Combat League. And we're submitting our apparatus. We've been talking to the sports division and Mr. Alvarez, and they've taken an initial review of it. We're going through details, but so far everything's been positive, and we just wanted to submit it publicly so anyone can comment on our fighting apparatus and take a look at it. For our event, we're looking to come in Texas in May during Consensus, which is a large Web3 conference. Another area that our league differs from other leagues is we have a Web3 component. So essentially, all of our fans can vote on different areas of the leagues. So it's important for us to be here during that time. And yeah, so that's essentially it from a high level.
Mr. Brown, thank you for your information. Excited to see how this goes out.
Great, thank you.
Have a good day. Christine, is that it for public comments? All these others are cases, is that accurate?
Yes, sir, that's it.
Okay. Thank you so much. All right, and so we're gonna go to item D, executive session. Commissioners, we'll now go into executive session to consult with our attorney under section 551.071 subsection 1 and 551.071 subsection 2 and 551.074 government code. The time is 8:48. After the executive session, we'll take a break and come back here. Mr. Jennings, how long do you think we need?
20 to 30 minutes would be my estimation.
So let's do 9:15. We'll be back here at 9:15 and pick up any action items on the executive session and then begin our case. right, I'm gonna call the meeting back to order. It's 10:24. We're back in open session, and there's no items on the executive sessions. We're gonna go to item F, which is the minutes. Commissioners?
So moved.
Is there a second?
Second.
All in favor say aye.
Aye.
Opposed? Motion carries. We're gonna go to item G, contested cases. If anyone is appearing in person for a case today, they will call upon you when you rise and be in the case announced. We'll hear from the prosecutor first, then we'll hear from the respondent, who will have the opportunity to speak. And make sure you speak clearly, say your name and who you represent. Make sure you speak in the microphones, please, also. Each side will have 5 minutes to speak and up to 3 minutes for rebuttal if needed. Christine, make sure you keep time for me if you don't mind. And check. Please understand the commission can only consider information that is in the record from what the case was heard at the SOA, so you must limit your comments to those matters that were present in the SOA hearing. So anything that you guys have that is given to us has to be presented in the SOA hearing. We're gonna go to item 3 on this, which is Calvin Walker, Natalie Olvera. Good morning. Good morning. Why don't you get on that side? 'Cause I'm a creature of habit. Thank you, sir. And we'll put prosecutor on. Gentlemen, good morning. Do you understand the rules?
We do, and we have materials to pass out to members of the commission. They're materials that were considered by the State Office of Administrative Hearings.
Thank you, sir. Prosecutor, have you seen the material?
We have seen the materials. We do have objections to 2 of the documents that are included in the packet. So we'd like to do some housekeeping matters on that beforehand.
Okay, let's go ahead and do that. And then outline them. Why don't you tell us what they are, then we'll make sure and we'll take them off. And commissioners, you'll have to dismiss those 2 cases, if you will.
I believe everyone has the spiral bound.
Not yet, but we're gonna pass them out now.
Oh, okay.
Yeah, go ahead and pass them out, sir.
You'll be receiving spiral bound, it looks like, of some of the documents. I think we can both agree that these are just excerpts of some of the exhibits. Of course, it's not the whole record of SOA, it's not the whole record of the exhibits. Thank you.
Jerry, if I may ask you a question?
Yes, sir.
Were you privy to all this documentation before, or you just got this today, or what?
We were, I've received it today, this morning.
But everything, you screened it, and
I have reviewed it, and then the 2 documents that we'll talk about, I'd like excluded.
okay.
Were those taken out of this book?
No, she's gonna highlight those 2.
I don't know which one she's talking about.
It's gonna be, so the first one is an affidavit. It was signed on January 29th. It should, I don't know if it was not included in the spiral bound. It's just a loose sheet of paper.
This one here.
This affidavit at the top, signed by Terry Williams on January 29th, 2024.
I'm not sure of that.
It's a 1-page document.
Mr. DeGuerin, do you know where that document might be in your,
I do, yes, that was just signed yesterday.
where would it be in the packet?
It was, it would be loose in the
Last
back,
page.
I think.
In the back?
Last page.
Last page.
Last page, thank you, sir.
It's right here.
So we're not to.
Just flip that over. Flip that over. if you don't
And that was
mind.
outside the records. And also, there's gonna be a stapled document, that's a printed version of an email that was sent to General Counsel's legal assistant, Terry Cooper. This contains statements that were also outside the record.
This is what that
this
is.
is this
The
piece
one
right
on
here.
top?
Yes.
January 29th?
Yes, that is my letter. It is what I intend to say to you today.
Okay.
And it's basically an outline of what is in this lengthy and voluminous
Okay.
spiral-bound document.
Out of abundance of caution, sir, what we're gonna do is we're gonna hear it, but we'll just put it down on the side so that we don't wanna. Okay, you can take it. Okay. All right. Anything else, Counsel?
No. So I believe there is another stapled loose document in there included.
Exhibit 15.
Yes, and, we're okay with the
Okay.
rest of it. And
Okay.
again, it's just, parts of the exhibit, not the whole exhibit, just so we're all on the same page.
Okay, all right, go ahead.
Again, good morning, Commissioners. My name is Natalie Olvera. I'm a prosecutor in the Enforcement Division. Trevor Phelan handled this case, but I will be presenting this case to you today. Trevor is no longer with the department. The ALJ recommends you revoke Calvin Walker's master electrician license. The ALJ recommends you revoke Calvin Walker's master electrician license and Mr. Walker's electrical contractor license based on his criminal history. I ask that you adopt the PFD as written, as modified by the exceptions, and revoke both Mr. Walker's electrical licenses. Prior to the SOA hearing, both Mr. Walker and the department agreed on the following stipulations. On or about in October 2019, Mr. Walker was convicted of the offense of securing execution of a document by deception where the value of the pecuniary interest affected was $200,000 or more, a felony. Mr. Walker was sentenced to 10 years confinement in the institutional division of the Texas Department of Criminal Justice, but the court suspended the sentence and placed Mr. Walker on community supervision for 10 years. Mr. Walker was also ordered to pay over $1.1 million in restitution to Beaumont ISD, Beaumont Independent School District. Due to appeals filed in the criminal case, Mr. Walker's conviction and sentence did not become final until October 10th, 2022. Mr. Walker is scheduled to be released from community supervision on or about October 10th, 2032. During the hearing, the department presented evidence the felony conviction was due to Mr. Walker, which also encompasses Mr. Walker's electrical company, submitted fraudulent electrical invoices to Beaumont ISD. Mr. Walker misreported Beaumont ISD's need for the parts, equipment, as well as the equipment used and the work completed on 2 schools. Beaumont ISD paid Mr. Walker almost $1.2 million for fraudulent electrical invoices, potentially putting thousands of children at risk. Additionally, in 2003, Mr. Walker received a deferred adjudication for insurance fraud, a felony. In 2012, Mr. Walker was convicted of willful failure to pay taxes. Fraud and deceptive trade practices are considered directly related to the duties and responsibilities of electricians, licensed electricians, because they have the potential and opportunity, as Mr. Walker demonstrated, to practice deceit, fraud, and misrepresentation related to the need for service and equipment, even the kind and quality of equipment being used. Consumers generally rely on electricians' experience and expertise, especially as a master electrician, as is Mr. Walker. Consumers trust electricians, again, especially master electricians, to know what is needed and required by code. And again, once electrician installations are complete, the work and equipment is usually covered or hidden from view, such as behind closed doors or behind a wall or in remote areas. Mr. Walker's conviction addresses exactly why fraud, deceptive trade practices, and theft are on the department's criminal guidelines for electricians. The department also presented evidence Mr. Walker is not compliant with all provisions of his community supervision, specifically paying restitution. This crime is not of youthful discretion. Mr. Walker was 48 years old when the crime was committed and 62 years old when the conviction was finalized. During the hearing, Mr. Walker testified he believes a union and the department are conspiring against him to take his license away. Mr. Walker also denied he ever submitted fraudulent invoices, even though, as stated earlier, Mr. Walker agreed with the department he was convicted of the felony, securing execution of a document by deception. Mr. Walker admitted he altered the electrical wholesaler's invoice, which was sent to Beaumont ISD, to make it look like Mr. Walker had bought equipment and so he could get paid for it. Mr. Walker also testified he has only paid $800 of the almost $1.2 million in restitution. The ALJ also noted Mr. Walker did not present any evidence why the public should trust him, that he has learned anything from his experience, or any evidence that Mr. Walker has been rehabilitated. If Mr. Walker's master electrician license and electrical contractor license are not revoked, this would create risk or opportunities for Mr. Walker to repeat his past criminal conduct. I again ask you adopt the PFD as written, as modified by the exceptions, and revoke Calvin Walker's master electrician license and Mr. Walker's electrical contractor license based on his criminal history. I'm available to answer any questions.
Commissioners, any questions? Okay, Counselor, go ahead if you don't state your name and who you represent, please.
My name is Dick DeGuerin, and I've been representing Mr. Walker since 2011. Mr. Butler, you've heard this case before. Yes, sir. So nothing will be new to you. This is at least the third bite that TDLR has taken at this apple. Of all of the voluminous records in this case, perhaps the most important are tab 5 of, no, tab 5 of our materials, which is a previous decision of this commission. The only common member is Mr. Butler, who was on the commission at that time and signed on that decision. And tab 11, which was another decision the same year from this commission, both of which denied TDLR's application to have Mr. Walker's license revoked. You might have noticed in the prosecutor's presentation that she said Mr. Walker was 48 when the facts occurred and 62 when the conviction occurred. Maybe that caught your attention. I've been representing him since 2011. The underlying facts that...
Objection, I mean, this is not relevant, Mr. DeGuerin, respectfully. How long Mr. DeGuerin has representing the respondent, that's outside the record. Mr. DeGuerin did not represent the respondent at the hearing.
Okay. We do need to stick to whatever the SO is, but if you don't mind, please.
Sure. Well, this is, of course, the fact of my representation doesn't matter. It's just, I say that in order that you know that I'm pretty familiar with the facts here and familiar with what's happened and what's reflected in all of the records to Mr. Walker. The allegation, the factual allegations, are all based on events that occurred in 2009 and 10 and 11. Nothing has happened since then upon which they base their application to revoke his license, except for a conviction in state court. But what the records show is that the first trial was in federal court on 37 counts alleging fraud against BISD. The jury could not reach a decision, and there was a later agreement between the prosecution and the federal prosecutors and the state prosecutors and Mr. Walker that the federal indictment would be dismissed if he would plead guilty to a tax violation, failure to timely pay tax. This commission found that that was not the basis and not a valid basis for revoking his license. This commission found that the underlying facts of that indictment were not a basis for revocation. They found so in the two decisions in 2014, which I've mentioned to you under tab 5 and tab 11 of our materials. Now, what happened after that? When Mr. Walker did not go to jail, and when he was put on a misdemeanor probation for a tax violation, the federal government also required him to forfeit over $4 million that he had earned in working for BISD. If you drive into Beaumont today, you'll still see the results of his work.
Objection, this is again outside the record, so if I can have a running objection.
The point is, there is no allegation of any kind of electrical fraud, any kind of fraud against Mr. Walker.
Mr. Chairman,
What happened after?
5 minutes.
Okay, I'm gonna give you another minute or so, Mr. Counselor, if you don't mind.
Okay, after he made the deal with the feds, one of the federal prosecutors went to the state and became the DA, and he brought the new charges, also based on the same exact
Is this
facts.
in the record?
No,
We
Yes,
can't-
it is.
It
It's
is
in the record. Yes, ma'am, it is in the records.
Okay,
part of it, yes.
okay. Is there anything else, Mr. Digger?
Yes. The conviction in state court is based upon the same facts that you have that this commission has already found was not a valid basis for revocation of his license. This is the third bite that they're trying to take out of the apple. And you should deny it, and you should allow him to renew his license and to keep his license.
Okay, rebuttal?
Yes, a short rebuttal. They have said that this is our third bite at the apple. That's not true. This is another case that Mr. Walker has come before the commission. The previous cases were under different laws and different statutes, different rules. This case is based on his criminal history, and his conviction did not become finalized again to all the appeals until 2022. So this is the first case that has been brought due to his criminal history background, and that is what this case entails. Again, all the arguments and what was done at the criminal trial, again, was heard by the ALJ, and as I said before, Mr. Walker did agree to our stipulations that he was in fact convicted of that felony. And we presented, the department presented evidence that he was also placed on deferred and convicted of other charges in his criminal history. So again, I'd ask that we focus on what the ALJ heard. They gave the appropriate weight they thought it deserved. The jury trial, again, heard all the evidence, decided that Mr. Walker was guilty beyond a reasonable doubt. That's why he has his conviction, and that's why we're bringing this case to you here now.
Mr. Digger?
Rebuttal. This is not the first case based on his criminal history. It's plain as day. If you will read your findings from 2014 behind tab 5 and behind tab 11, that 2003 deferred adjudication, not a conviction, was considered there. Also, all of the facts that they're basing their motion on were considered by this commission. Under state law, or actually under federal and state law, there's what's called a dual jurisdiction. And so double jeopardy is not implicated here. But that's because there are two sovereigns, the state and the federals. There's only one sovereign before you, and that's you. You've already considered everything that they've asked, and you've also said he should not be revoked.
Okay, thank you, Mr. Commissioners, questions?
I have a question. Counsel, can you read me fact finding number 6 and 7, please, for the record?
Who are you addressing? Our prosecutor?
Oh, our prosecutor, I'm sorry.
Sure, of the ALJ's proposal for decision?
That's correct.
Sure.
Fact finding.
I will pull it up real fast.
That way I've got it in front of me.
Oh, okay.
Commissioner, I'd be happy, Doug Jennings, General Counsel. In the PFD, finding of fact 6 and 7, 6 reads, on or about October 1st, 2019, in cause number 14-19966, in the Criminal District Court of Jefferson County, Texas, respondent was convicted of the felony offense of securing execution of a document by deception where the value of the pecuniary interest affected was $200,000 or more. He was sentenced to 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspended respondent's sentence, placed him on community supervision for a period of 10 years, ordered respondent to serve the first 180 days of that period in county jail on weekends, and ordered respondent to pay $10,000 in fines and $1,172,656.92 in restitution. Finding of fact 7, respondent unsuccessfully appealed his conviction, and the conviction became final, and respondent's sentence began on or about October 10th, 2022.
Thank you, counsel. Also, can you also get me the conclusion of law, for the record, number 5?
Conclusion of law number 5 from the PFD. The department may revoke the license of a person who has been convicted of an offense that directly relates to the duties and responsibilities of the licensed occupation, and the citation is Occupations Code 53.021, subsection A1.
Thank you, counsel. Defense, can you explain me, because you were talking about the federal cases, here we're talking about the one which happened in the criminal court in Jefferson County, and also the law which we are bound by what we got to do.
Yes, the underlying facts of that conviction are the same underlying facts as the federal indictment, which you have considered the underlying facts as not justifying his revocation.
And if I may, Commissioner, quick response, Natalie Olvera with Enforcement. The previous cases, again, that were before this commission were about program violations within the electrical statute and violating the electrical code. They weren't based on criminal history.
Fair enough. Thank you. Chair, I don't know.
May I respond to that?
Sure.
That's not correct. That's not correct. Just read your findings under tab 5 and tab 11. The findings of fact as well as the conclusions and what you did. It's the same case.
Yes, sir.
Mr. DeGuerin, where are we in the restitution? I know it's a very recent case, but so where are we in the payback period and how far along are we?
And Mr. Butler.
I can answer that. Excuse
I'm
me, but that's
sorry.
to me.
The only thing that we're allowed to
excuse me.
consider.
I'm allowed to, the Commissioner, he has a question, let him just,
Oh, sure.
go ahead.
Okay, thank you. Where we are is the federal government grabbed $4 million from him and tried to give it back to, or tried to give it to BISD. BISD refused to take it, saying we weren't defrauded. All that's in this record. BISD says they weren't defrauded. They refused to take restitution.
That's in this
But,
record.
yes, it's in here.
Where is that, Mr. DeGuerin?
Is it in the sewer packet?
Tab number 1, it is.
It is in respondents exhibit. It's based on a motion.
It's the first page of tab number 1. Real simple to look at it.
But Mr. DeGuerin's argument, Mr. Walker's argument of there's no victim in this case was heard by the ALJ. The ALJ dismissed it, gave it the weight that it deserved, and decided that's not what this SOA case is about. That's not what the law and the procedure of this specific SOA case is about. Again, we're basing it on the conviction, this conviction, and his criminal history, and that's what this case is about, not whether there is a victim or not that wasn't prudent to this specific SOA case.
Okay.
I understand that, but it's all based upon this underlying criminal law offense, and there's a restitution component to that.
Yes, which is required by his conviction.
Any other questions? Okay, I'll take a motion.
Should I move to adopt the PFD as issued by the ALJ?
Is there a second?
Second.
Okay. Any further discussion? All those in favor say aye.
Aye.
Opposed?
No.
Let's take a roll call vote, Christine.
Yes, sir. Commissioner Sajid Raksaram?
Aye.
Commissioner Rory Hine?
Aye.
Dr. Gary Wesson?
Aye.
Commissioner Nora Castañeda?
Aye.
Vice Chair Tom Butler?
No.
Chairman Rick Figueroa?
No. Okay, motion passes. All right, we'll have other opportunities beyond this, Counselor, and then our staff will let you know what those next steps are. Appreciate it, Mr. Walker. Appreciate it.
Good to see you again, Mr. DeGuerin.
Thank you. Good to see you, Mr. Butler.
Is Mr. Dixon still making wine in the
He
hill
is.
country? That's good.
All right, next case.
Are we excused?
Yes, sir. Yes, sir. Thank you. Justin Perez and Jessica Hurtado. speak, sir. Go ahead.
Good morning, Chairman and Commissioners. Jessica Hurtado with the Enforcement Division. In this case, at the last meeting, you heard this case against Mr. Perez, and you had remanded this action back to the department to try to work out a restricted license agreement. And today I'm asking for a continuance again for additional time to try to work out something with Mr. Perez and to get that done.
So we're looking for a motion?
I'll make a motion.
Second.
All in favor, say aye. Aye. Opposed? Motion carries. Thank you, Jessica.
Thank you.
Ricardo and McNeely. Sir, have you understand the rules that I spoke earlier?
Yes, sir. Yes,
Okay.
sir.
Okay. Go ahead, Jessica.
Jessica Hurtado, Enforcement Division. The ALJ recommends that you grant Ricardo McNeely's apprentice electrician license application. I ask that you reject the PFD as written and deny the application because of Mr. McNeely's criminal history. In 2015, the applicant pled guilty to felony assault by impeding the victim's breath or circulation. The applicant squeezed the victim's neck with his hands and forced her against the wall. The court deferred adjudicating the applicant and placed him on 3 years community supervision. Then in 2017, the applicant was convicted of felony assault. His community supervision was revoked on his prior offense and he was sentenced to 3 years in prison. In 2020, the applicant was again convicted of felony assault by impeding the victim's breath or circulation and sentenced to another 3 years in prison. He was 42 years old when this offense occurred. The applicant was released from prison on March 9, 2022. Assault is a guideline crime against the person that is directly related to the duties and responsibilities of the electrical occupation. If granted a license, the applicant will be in direct contact with members of the public, including inside their homes, in situations that have the potential for confrontational behavior. This is a serious concern for the department because the applicant's repeated assaultive offenses establish a record of conduct in which the applicant has shown an inability to remove himself from confrontational situations. Chapter 53 of the Occupation Code includes the factors that you as the commission must consider in weighing whether an applicant should be granted a license. The department felt that those factors weighed against granting the license. The ALJ weighed those factors and found they weighed towards granting the license. And so I'm asking you, the commission, to look at those factors and decide whether you should grant the license. The department is opposed. We ask that you reject the PFD. I'm available to answer your questions.
Any questions? Okay, Mr. McNeely, go ahead.
Once again, good morning. My name is Ricardo McNeely. And the first thing I would like to say is that I did do my time as a crime I committed, and I submitted numerous paperwork from my supporters, my sponsors, people that helped me get past where I'm at, get me to where I'm at now. So I submitted numerous paperwork saying, and I also went through a rehabilitation course out in prison as well as outside. And the next thing I want to say is that when I got out of jail, I went to school. I went to electrical school, Forge now, and I did a 9-month course there. And after the 9-month course, I went on to work with JMIG. And from that point on, I had received that I didn't receive my electrical license, and that's when this is like he said, the apple want to take his bite. It's the third bite out of the apple. I've been to court 3 different times, and I've been approved for an electrical license. And every time that I've come to get approved, I have some kind of rejection from Ms. Harbardo here. But I'm here just saying that I have done, and this is my wife right here as well. This is what's going on, so it's nothing that we're not divorced, not separated, we're still together. And I'm here just trying to take care of my family. And I understand I made some wrong choices, and I accept those choices. But I want to let you guys know, as well as Ms. Hurtado, that I've taken the choices, I've taken the steps to get myself back on track. And like I say, I'm 42 and I'm right, and that's when that happened. Right now, I'm 46 years old. This has been over 5-6 years now. And I'm currently not working with electrical, but I have a job. So I'm doing everything that I can do and to stay on top of whatever I need to do. And once again, I talked to Miss Linda Burgess at the hearing, and she granted me my license. Everybody has granted me a license to work and take care of my family. And this is what the state says, that they're not want to prohibit, but they want to help. I've been there, I've done it, and now I'm back, and I want to rehabilitate. I've been rehabilitated, and now I want to go forward with my life. I'm not here. I'm living in Dallas. I took a day off, vacation day, to take off, to come down here to let you guys know that I am who I say I am, a rehabilitated member of the society. And that's all I have right now. Okay.
Any questions, Commissioners? Yes, sir.
Mr. McNeely, thank you for coming here today.
Yes, sir.
Thank you for facing us.
Yes, sir.
Your crime is very current, it's very recent.
Yes, sir.
So I don't know exactly what the commission's gonna do today, but there's some things I'd like to ask and some things I'd like to say to you.
Okay.
It seems to me that you're probably not a threat to the community at large, but you are a threat to those that love you, and that's the saddest part.
That is. And
That's the saddest part.
That's true.
Because those are the ones that want to protect you.
Mm-hmm.
And so a lot of times these crimes don't get reported.
That's right.
Are you currently in anger management classes?
No, sir. I've graduated the class. I have certificates that I submitted to the SOLA, saying that I've graduated all those courses and classes.
So, anger management, a lot of experience with anger management, helping people through the process. You said you're rehabilitated. It's much like alcoholism, right? There's kind of a cycle to it. And then there's a release, and then regret, and then the cycle builds again. I would encourage you to continue that.
Okay.
Just because it's imposed on you from an outside force, a court, or maybe this commission. An electrician is what you do with your time.
Yes,
it's
ma'am.
not what you do with your life.
Right. Exactly.
You understand?
Exactly.
What you do with your life is what makes you look in the mirror and say, I'm proud of that man.
Sir.
It's not what you do with your time. You give your time to make money as an electrician. You give your love and your effort to make a life.
Yes, sir.
And so I'm really concerned, to be perfectly honest. I mean, you've had so many run-ins with the law, and it's always with those closest to you, those that you love. So I think that's all I have right now, Mr. Chair.
Okay. Yeah. Mr. McNeely?
Sir.
Looking back at the violence history in 2015, 2017, and 2020, fair enough?
Sir.
So recurring of either 2, 3, what the time frame, what it is. Given the fact what you've been through this recent, and I understand that you've been in 3-year confinement, and this is what you started, again, your rehabilitation, this is a second approach. I do encourage you to control your anger, because I think, we don't want to see again 4, 5, 6, or,
Exactly.
every time.
Exactly.
You're making steps right there to do the right thing, but I think you need to be a little bit monitored a little bit, so that you won't get back into this cycle right there.
Sir.
So that's what we're gonna be looking at it, and thank you for trying to come back to the society right there.
Yes, sir. Yes, sir.
Thank you, Chair.
Yes, sir. Any other comments?
Can I?
Mr. McNeely, make it quick, please.
Okay, I want to speak, and I appreciate you, and that's what I'm saying. That's what I'm working on, rehabilitating myself as well as my family. That's why we had an opportunity to get a divorce and go our separate ways, but we chose to stick together and work as a team with this here. And this is what I'm trying to do, really rehabilitate myself as well as my family, and take care of my family. That's it.
That just tells me you don't deserve the woman that you're with, to be perfectly honest. Okay, so, Mr. Chair, I'm gonna make a suggestion that we suspend, or that we revoke Mr. McNeely's license, but we suspend the revocation. And I would ask enforcement to please monitor his license. I'd like to make sure that he's in anger management classes for several years. Mr. McNeely, if the commission goes along with my suggestion here, my motion, you will get to keep your license, but you will have to take anger management classes.
Yes, sir.
For a long time.
Yes, sir.
This is not going away because you serve 30 days in TDCJ.
Yes, sir.
This is a lifelong thing that you've had to struggle with. I hope you're struggling with it.
Yes, sir.
I hope you're on top of it for your wife's sake. That's my motion, Mr. Chair.
Could I ask you
Sure.
a question? Could we, in that same vein, remand this back to enforcement so that they could build an agreement addressing the concern that you have? Is that a better positioning? And am I phrasing that better than what you were? Because I think that it would be better suited. I mean, Jennings, correct me if I'm wrong, is that correct?
I've got a couple options for you, is what it sounds like, Commissioner Butler and Chairman Figueroa. One option would be to remand this matter back to enforcement to work out an agreed restricted license. At least enter into those discussions, and if those are not fruitful, then bring the PFD back to you. I think you could also this could be your opportunity to give enforcement some direction about what type of provisions you would like to see included in that potential agreement. The other option, I think, would be issuing the license and suspending it, but probating the suspension and placing conditions on that probation, such as attending anger management or some sort of regular reporting. Either way, I think we get to the same result.
The motion that I made.
The first one or the second?
The third one, where we issue the license, but we suspend the license, but probate that suspension.
Correct. We can do that.
Under conditions such as anger management for a term of period determined by enforcement.
Okay, well, so we've got some branching paths here. And so, again, sorry, Doug Jennings, General Counsel. I think if you do not have a discrete term in mind, I think your better option would be to remand the case for an agreed restricted license.
I just want to make sure that we consider Commissioner Butler's concern.
Absolutely.
I just want the hammer over his head.
Right. And, I know,
Perfectly honest.
and enforcement is here to
I-
listen to your recommendations.
I wish nothing but the best for you, but I want you to be concerned that it's gonna come down on you.
Oh, yes, sir. Yes, sir.
I think you need that, but,
Let me give the commissioners time to respond.
Sure,
to you.
sure.
Yeah, absolutely. So
Can I-
there's a motion.
Before you make.
Just a second, sir. There's a motion, right, and I want to make sure I get the motion correct, that we're going to remand this back to enforcement with the consideration of anger management training or therapy. Is that accurate? Is that fair? And is that accurate?
Yes, sir.
Okay,
That's what I'm
so
hearing.
that's a motion.
Okay.
We grant the license, but it would be restricted. Right.
So we're not deciding to grant the license today. What we're deciding to do, based on what I've heard from you, is to send the matter back to enforcement to pursue that agreement between the department and the respondent that would set out the terms that you've addressed. A restricted license could be reached. Of course, there's no guarantee that process will be successful. But if not, we will bring this matter back before you. But that's.
I want to make sure that's clear. And there's that's the motion. Are you good with that, Commissioner Butler?
yes, sir, I am, and
Okay.
I'll amend whatever motion.
Is he
No,
allowed
that's
to
good. It's a good
work?
motion. It's
Okay.
good.
Thank you.
Is he allowed to work in the meantime?
Yeah, he would be, yes, until they get agreed upon conditions. If they can't agree upon the conditions, it'll come back to us.
He does not, I'm sorry, just some clarification. I want to make sure, Mr. McNeely does not yet have a license.
Okay.
And
No,
so
sir.
he will not be able to work in the electrical field until either this commission
had-
grants some sort of license or an agreed license, an agreed restricted license is entered into.
Okay, so we got the motion. Any more clarifying points on the motion? Okay, is there a second?
Mr. Chairman, can I just offer one thing? In regard to the anger management courses you're talking about, I think there needs to be some type of stipulation that says completing a course annually, once a year, quarterly, but I don't think there's a year-long course, so I want to make sure that we get to where you want, but I think having some type of stipulation that it's done at least annually for the next X number of years, I think is where you're going.
Sure, I'll be happy to do that. I just kind of want enforcement to have that option.
Yes,
right?
sir.
And so what's the best way to square that circle?
I just think, I'm sorry.
Yes,
Jessica, please.
If we're talking about multiple years, I think then a probated suspension is probably better because a restricted license term is for a single year. And the statute states that unless we have good cause, we have to go ahead and grant a full license after the first year. So we would be in a hard spot to do multiple years.
That's why my initial motion was the granting the license once the conditions are met, and then suspending that granting of the license.
Yes, and then we could do,
Or probating the suspension.
right, we could
Maybe
do
a
a
better way to
probated
phrase it.
suspension for more than 1 year.
To let enforcement determine
Okay, so you got a little ambiguity in this motion.
Yeah,
I'm
I'm
sorry.
lost. I'm
Do you have
lost.
a fixed number of years that you want this done, that you're offering in the motion?
I really don't. I'd like, does the commission, I mean, can we discuss it? I
Yeah,
don't- I
I'm
really
trying to
don't.
get your motion clarified first before I can discuss it.
I
yeah.
don't.
Chairman,
I'm sorry.
may I weigh in just one more time? Thank you. I think regardless of which option you choose, we can get there. I agree with Ms. Hurtado about, the term of a restricted license. I think there's some things that we could work together in an agreed order to make it work regardless of the term. I think there's some things we can agree upon. But I think it sounds to me like we kind of reach the same point either way. I think if your desire, put it this way, if your desire is today to grant Mr. McNeely a license, but put reasonable restrictions on that, then I think your better option would be to grant the license, suspend it, probate the suspension with the terms and conditions that you require. If you would like to give enforcement some opportunity to work out those details and try to come up with something that fits Mr. McNeely's circumstances, then I think you would go with remanding it to enforcement to work on that restricted license agreement.
Yeah, I agree, Mr. Butler. Doug, we want the spirit of what Commissioner Butler is trying to do here, right?
Right.
Which is two things, from what I understand, is one, to put a conditionary scenario on the license, and to make sure that there's injection of anger management into it. Okay, so I would like for you to make sure that those spirit of that motion is, if it does get passed, we can have the other commission. I'm open up for discussion in a minute. So which way do you want us to go, the verification or the?
Why don't we proceed with, Ms. Hurtado, if you disagree, I'm open to persuasion. I think probably the better option, from what I'm hearing from you, a desire to issue Mr. McNeely a license, but place restrictions on that. I think probably the better option would be to grant the license, suspend it for a term of years that you should decide here, and probate that suspension, and place conditions on it such as periodic reporting, maybe monthly, maybe 90 days, maybe 6 months.
To allow enforcement to work
Yes,
that out.
and completion of a recognized, we may grapple with the terminology here, but a recognized anger management program to complete that program. For example, and I'm not familiar with the number of programs.
I'd like it, but to allow enforcement to be able to do that. I don't want to have to get into details.
Okay.
Let's stop there.
If we're sending it to enforcement to make that determination, I think
That'd be great. I
the
think-
appropriate
you okay with
motion
that,
is
Mr.
to
Butler?
is to
Okay.
table this case for now, remand the matter back to enforcement to pursue an agreed restricted license, and then GC can work with enforcement to effectuate that.
Correct. I think he wants to honor enforcement's efforts. Okay.
All right.
That's the motion. Is there any questions? A second?
Second.
Okay, any further discussion on this motion? Not that we haven't had fun during the motion. All right, all in favor say aye. Aye. Opposed? Motion carries.
Okay. I don't, hold on, please.
I know.
Okay.
I'm not the same way.
I
I'm
wanna make
just
sure, I wanna make
confused.
sure I understand
Okay,
what's going
so
on.
let me do this for you.
Okay.
So we'll have the staff get with you and explain to you what happened, okay?
Okay.
How the process went, okay?
Okay.
They'll be clear with you. If you have any questions, they'll make sure and outline it for you,
Yes, sir.
okay?
Yes, sir.
Just make sure, they'll get with you, okay?
Okay.
All right,
Sean.
but thank you. It's a good thing.
Okay.
It's a good thing.
Okay, I
It's
just
a
wanna
good
make
thing.
sure,
Let me-
I want
let
one
me-
more quick,
it's a-
am I
it's a good-
able
it's a
to
good
go
thing.
back to work?
Chairman, we have John Medlock ready to assist the respondent.
That gentleman right there.
All right.
Thank you, Mr.
I just wanna go back to work.
I'm as confused as you are, bro.
Go back to work, Mr. McNeely.
Bottom line, don't ever come back here.
Yeah. I promise you.
Well
I
said,
won't.
sir. Well said.
All right, thank you.
That should
guys.
shake him up. That'll keep him
Yeah,
up
they
right
got
there,
me.
right?
You
All right.
said put your hand up.
Okay,
Thank you, Commissioners.
number 4.
Thank you, yes.
No, we did,
Are we, Cynthia, are we on number 4? Am I?
we moved that one up.
Cynthia Marple and Leone Tony. Okay. Thank you, Commissioner Butler, for backing that.
Sorry, he complicated it. Sorry, I complicated it.
That's,
It's my superpower.
all right, did you understand the rules that I said at the beginning?
Yes, sir, I did. Thank you.
Okay. Ms. Marple, go ahead.
Good morning, Commissioners. My name is Cynthia Marple. I'm here on behalf of the Enforcement Division of TDLR. We're here to discuss the SOA case, and the case involved a non-consent private property tow of a non-residence vehicle from a parking lot of an apartment complex. The ALJ's PFD concluded that the department failed to prove all the elements of its case by a preponderance of the evidence. We believe that the ALJ made that determination based on an evaluation of the witness's credibility. She gave equal weight to the witnesses. Therefore, the ALJ only gave the department a 50% weight to its evidence in the witness's testimony, which means we couldn't meet the required 51% or more to meet the preponderance of the evidence standard. And we request that you adopt the PFD as written. Thank you.
Excellent. Any questions? Do you understand, Counselor, what she is?
Yes, that we're asking, she's asking what I'm asking for.
Right.
You adopt the PFD and we all go home.
Yeah. Counselor, do you have any comments on that?
No, a suggestion. My clients paid me to be up here, and a call before today would have certainly helped and saved the taxpayer money from having to come here. We're literally a phone call away when we can come to an agreement on things. But thank you for your time.
No, understood that, Counselor, appreciate it. I think this is gonna warrant, maybe some rules. So I would tell you, Mr. Jennings, you probably need to look at that as well to keep this confusion. Okay, so I need a motion.
So vote to adopt a PFD.
Is there a second?
Second.
All in favor say aye.
Aye.
Opposed? Motion carries. Thank you.
Thank you all.
Thank you for your time. All right, we'll go to rules. Item H. Mr. Reyes? I'm gonna tell you what, Mr. Reyes, can you stand by? I'm gonna say it's 11:11. Let's take a 4-minute break. So 11:15, we come back here, that'd be great. I know we didn't take one, so if you don't mind, I'll hold off.
Not at all, sir. Thank you.
Thanks, sir.
Is that the rule?
All right, it's 11:18. We're gonna get back and we're gonna rules, Mr. Reyes.
Yes, sir.
Item H, Commissioners.
Chairman, Commissioners, I am Robert Reyes, Assistant General Counsel. I'm presenting the Industrialized Housing and Building Rules package that amends Section 70.100 and 70.101 of the Texas Administrative Code. This is the first package of a possible 3, which will modernize the program. The subject matter of the next package will include any action to be taken on the comments received in response to this rulemaking and relate to third-party inspections. The Code Council determined that the mandatory building codes, as found in 70.100, needed to be updated. The proposed rules update those codes to more recent versions, which account for advances in technology and safety, as well as amend those codes in 70.101 to tailor them to the specific needs of Texans. A few highlights of the rules package. By adopting this rules package, the 7 international building codes will be updated to their 2021 editions from the current 2015 editions, and the National Electrical Code will be updated from the 2020 edition to from the current 2014 edition. All the codes since their last adoption have undergone reorganization, which affected their numbering and lettering. We have tracked all those changes in this package. Additionally, Section 70.100H has been amended to reflect the fact that the International Energy Conservation Code is adopted by the State Energy Conservation Office. The amended language now authorizes the automatic adoption of whichever version of the IECC that SECO adopts. This will allow our rules to evolve in a more efficient and expedient manner, as well as have the rulemaking only necessary for amendment when specific sections of the IECC are necessary, or if we need to postpone an adoption date for such. Language to resolve any conflicts between the IECC and the International Building Codes have also been added. You may also remember the rule package for the electricians program regarding GFCI breakers and HVAC equipment. The incompatibility between them was leading to nuisance trips, which required costly resets. To maintain consistency between the programs, that section of the NEC, Section 210.8F, has been removed. The proposed rules were published on September 22nd, 2023, and the comment period closed October 30th, 2023. 4 comments were received in response to the package, and while we found that none of the comments were determined to be directly related to the rule language proposed, the comments will be forwarded to the Code Council Rules Work Group for analysis and further rulemaking. Before you are the proposed rules with a technical change that was found after the Code Council's review and decision to adopt the rules. That technical change is found in 70.101I3 and has been marked for your convenience. That change is technical in nature and does not change the complexion of the rule paragraph. Staff recommends that you adopt the proposed rules under Administrative Code Chapter 70, including that non-substantive change with an effective date of March 1, 2024. I would like to make clear that according to Administrative Code Section 70.101A, the amendments that you adopt will be effective 180 days from following the date of the Code Council's approval and determination. Therefore, the date for the industry to begin following the adopted code version will be May 14th, 2024. I am here, as well as staff is here, to answer any questions you may have.
Thank you, Mr. Ray. Any questions?
Just a quick question.
Yes, sir.
So, we changed the rule because the nuisance trips, right? Remember
Correct,
we
sir.
kept tripping out because there was a change in the manufacture process of, what was it again? Do you-
There was some mechanism that was causing the trip inside of it. Technology hadn't reached to that point yet. There was emergency rulemaking. In fact, General Counsel, Mr. Jennings, was in charge of that emergency rulemaking, waiting for technology to catch up to the current, to what was currently in the market.
And I can follow up if you wouldn't mind, Commissioner Butler. Doug Jennings, General Counsel. A notable thing is that when so that 210.8F was the problematic provision in the 2020 NEC. Once again, that was an incompatibility between GFCI breakers and certain outdoor electrical equipment, including air conditioning condensers and the like. Really caused every state to look at those provisions very, very carefully, and our commission, by emergency and then permanent rulemaking, removed the applicability of that provision. Actually does not appear in the 2023 NEC at all. The code, the NFPA, now National Fire Protection Association, has deferred any action related to that until at least the 2026 code. And so really, what Robert is suggesting, the change to the 2020 code, is really going to make sure that the provisions are consistent between the 2020 and the 2023.
So we're just changing the code to accommodate technology then, right? I mean, technology hasn't gotten any better. They were going to go back and re-engineer that. Did they not? I mean, are we just stuck with it the way it is, and now everybody's changing the rules to accommodate kind of the broken system as it is?
My understanding is that the industry and the code-making panels are sort of in limbo right now, and extending the timeline to talk about it and for that technology to hit the market and become more affordable.
Sounds a little crazy, but okay.
It's crazy, and there are
It
8
is
codes
crazy.
that we are working on here in this program. Electricians only have the NEC, so this is an amalgamation of a lot of work from a lot of people from a lot of entities all around the world.
Bigger than Texas?
Just a little bit.
Just a little bit.
Any further questions? All right, I'll take a motion. Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? All right, motion carries. Thank you, Mr. Reyes.
Thank you for your time, sir. Thank you, Commissioner.
Item I, Laura Pfefferly, and I guess Chris Funderburg, right? Welcome.
Chairman, Commissioners, my name is Chris Funderburg. I'm a new Assistant General Counsel, formerly with our Enforcement Division, and now assigned, part of my duties include the Behavioral Analysis Program, which were, until now, just now, formerly managed by Laura Pfefferly. Well, this is the first time that I've appeared before this iteration of the Commission. I've been with TDLR Enforcement Division for more than a decade, and I'm excited to continue to represent, continue with TDLR, this time as a member of General Counsel Division. As this transfer of duties is so recent, the historical knowledge that is necessary to answer any questions you might have about this rule package lies with Laura, and so at this point I'm going to transfer the microphone and just transfer the microphone and allow Laura to answer any questions about it that you might have. But again, thank you for your diligence in serving the citizens of Texas, and I look forward to working with you. I know, right?
It's been a long
I was trying to look back. Maybe 19? Seems like it's been a bit.
Before COVID, yeah.
Yeah.
Thank you, Chris. My name is Laura Pfefferly. I'm an Assistant General Counsel, and we're here presenting the rule amendments to Chapter 121, Behavior Analysts. They primarily treat autism. The rules were first proposed about a year ago. They were republished in September to incorporate some changes resulting from some public comments from the Texas Association of Behavior Analysts Public Policy Group and from the Texas Medical Association. The rulemaking basically reorganizes the telehealth provisions and divides the rules into subchapters to improve the organization and user friendliness. And there's quite a bit of updating in it. There were no public comments during the comment period, and the board supports all of the rule changes and the reorganization. The GC recommendation is to adopt the rule to become effective March 1st, 2024. If you'd like more details before you vote, I'll be happy to provide them.
Excellent. Any questions? I'll entertain a motion.
Adopt the rules as presented.
Is there a second?
Second.
All in favor say aye. Opposed? Motion carries. Thank you.
Thank you.
Thank you so much.
Good seeing you, Chris.
Thank you. Good seeing you.
All right, item J. I'm not sure who's going to do this.
I don't mind handling it, Chairman, if
Okay.
that would be okay.
Okay, Commissioners, we're gonna skip item 1 under J and 2 under J also gonna skip, if you don't mind, or postpone, if you will, item 6.
Yes, Chairman. Doug Jennings, I almost said Assistant General Counsel. Doug Jennings, General Counsel. So just a clarification for the record. We will not be considering items J1 or J6 this afternoon. J1 was drafted in anticipation that you would have some PFDs from SOA that the Vet Board had reviewed. Both cases were continued at TBVME's last meeting, and so we'll bring those to you at a future date. And similarly with the rules, the proposed rules that the Vet Board recently looked at, they're not ready for approval by the Commission yet, but we will bring them to you when they are. And so items 2 through 5 remain, and we would like to ask you for your approval of TBVME's recommendations regarding approval of agreed orders and dismissal of cases. You can see the case numbers under each individual item, and I believe we can dispose of this in one motion. I'm happy to answer any questions. And Brittany Sharkey, the Executive Director of TBVME, is present today, should you have any questions for her about the process, and she's indicated to me she's happy to do so.
Good to see you, Brittany. Any questions? All right, I'll entertain a motion.
So move to adopt, the 2 to 5 as recommended by the council.
Good motion. Second? All in favor, say aye. Opposed? Motion carries. Thank you.
Mr. Chairman, Brian Francis, just know that in the future, you're gonna continue to see the Vet Board attachment evolve. And so as rules come to you, there'll be a little more specificity. As cases come to you, you'll have a little bit more background, but this is our first iteration. But it's going to evolve over time, and I'm just grateful to the work that Brittany and her team have done. They have been so receptive in working with our staff. The back and forth it's a really good dynamic, so I'm excited about that. But it's going to continue to move forward. It's going to continue to move forward. So we appreciate the confidence in moving forward with us today. Thank you.
Mr. Francis, I apologize. I was intending to roast you at the very beginning of this meeting, and
So you let me
welcome
marinate
back.
a little bit,
I
and
did.
then you're gonna roast me later.
Well, you limped in here a little bit.
You felt sorry for me.
I did. It was a pity that, but it is great to see you in that seat. It is great to see you. Thank you for your coming back. Thank you for your efforts, and I know it's a labor of love, so we appreciate you being there. All right.
Thank you. I really do appreciate that.
Absolutely. All right, item K, Randy.
Good morning, Chairman and Commissioners. On your tables, you should have received a document that looks like this morning. Has a bunch of numbers on it and some blue subsections. So this is our operating budget for fiscal years 24 and 25. And so if this looks familiar to you, it should be. You've actually seen 2 iterations of this prior to now. The first one that you saw was in July of 2022 when you approved the legislative appropriations request, when we had all of our exceptional items listed, and you approved that. And then at the end of session this past summer, we reported to you the adopted appropriations by the legislature and the enacted legislation that impacted the agency. So what you have in front of you is just the final 24 and 25 fiscal year operating budget, and it has some informational listings as far as what the objects of expense are. You can see that our total biennial budget is $137.8 million. And so we're coming to you today and just want to get your formal approval of this budget as we move into this biennium.
Okay. Any questions?
Chair, I want to ask you, applaud you for putting this budget right now. And can we also see the tracking? Because last time we saw that when if there are any shortcomings or something, if you need to move around or something, we can take a look because.
Absolutely, Commissioner. So we do look at the budget monthly. We are reporting that to the Audit and Finance Work Group, and we can make sure that you get those documents as well. But it is being tracked every month, yes, sir.
Thank you. The LRM is that's the main document, basically.
Yes, sir.
That's the main, okay. All right, this is procedural. I entertain a motion.
So moved.
Second.
All in favor, say aye.
Aye.
Opposed? All right. All right, item L, Mr. Forster.
Good morning.
Good morning.
Todd Forrester. I am program specialist of several programs here at TDLR, along with my director, Charlotte.
Hello, Charlotte Melder, Director of Compliance.
And I also work for the Compliance Division. We are here today to talk about the Methods and Assistance Program, the MAPS program. Once a year, the comptroller sends us a list of counties that have not met the requirements under the Methods and Assistance Program. We then have a year to work with those appraisal districts to get them to come into compliance. This past year, we had 11 counties that came to us. We were able to get all but one corrected, everything corrected in all but one. We have just received the new Methods and Assistance Program counties for this next year, and it's 28, so it's quite a bump up. I've already started emailing and contacting the appraisal districts in order to get that process moved on. I really would like to get 100% this time. We weren't able to this last time. We were able to get 99%, which is more than classically had happened. You know, I'm working as hard as I can, like any other program I have, and so far we've been able to have some limited success, but we hope to get 100% going forward.
Excellent. Any questions?
Sure, I'm gonna ask a question. What do we do if something doesn't meet requirements if they fail?
So we work with them. We get a list from the comptroller's office for all the counties and what the deficiencies were, and we work with them on however we can to get them to come up into compliance. You know, there's various reasons that they could not be in compliance. Some of them are tough. Some of them, it's for not posting a meeting on a certain date when they're supposed to. We can't go back in the past and change that. So we work with them on their policies and procedures, something in writing showing that next time and going forward, this will be corrected.
Thank you. Any further questions? Yes, Charlotte?
I just wanted to really quickly say that since Todd has taken over this, it was added onto his responsibilities. We had never gotten more than half done. He got all but one. And he is working really, really hard, and I have every faith that this is going to go fantastic this year.
And Charlotte, that's exactly why I asked him to increase the number to 28
Wow.
to test Todd's mettle.
Wow. Would you like me to roast them now? I can do that now.
You know,
I got no material on them.
It's oddly motivating. It's motivating because I'm like, okay.
So you're a masochist. I get it.
Right.
I got it. Okay.
Maybe
Any
he'll
other
help you.
questions?
Maybe he'll help you.
All right, thank you
Thank
so
you.
much. Thank you, guys.
Good job.
Good job, y'all. Thank you.
All right. Item M, the work groups. Sharon, I guess we talked about that one. We're good. Anything here? Go, come on. Commissioner Wesson had to go, so.
Thank you, Chairman, Commissioners. Sharon Hamoya, Human Resources Director. I just wanted to provide a quick update on the Human Resources Commission Work Group. As y'all may recall, the December 1st meeting, the work group was tasked with exploring procurement options for an executive search, as well as the statement of work for possible procurement and selection of a successful bidder. The work group has met twice since then and has developed a draft statement of work that has been through review at TDLR and has been sent to the comptroller for approval prior to it being posted on the procurement website looking for bidders. So currently we are in that holding process, and we will update the commission as soon as we're able to formally post. I don't know if there's any other questions.
That's it. Any questions? All right, thank you so much.
Thank you.
Innovation? Mr.
Sure, man.
Francis?
I think we're fine. I'm gonna bring up John Fowler to just give you a quick, very high level overview, particularly of the.
Use small
NLS.
words.
Yes, sir. Yes, sir. John, thank you.
Good morning, Commission. John Fowler, Chief Information Officer. And yes, due to the public nature of this meeting and the active procurement, we're not allowed to say a lot, otherwise Ms. Myers will
You bet.
have at me. We continue to work with our vendor partner who is helping us develop the RFO. By state procurement law, there are a couple of specific gates that we're required to follow. Those include reviews by external entities, other agencies. We've passed one of those gates. We're finalizing the second one. After we do that, we will publish the RFO. We intend to have a bidders conference. We will have a formal Q&A period where potential vendors get to submit those. We will provide our answers in writing. They will submit their bids. We will score. We will have demonstrations, and then negotiate and execute that contract. But we're finalizing the second part so that we can get to the second review gate with the external entity, the other agency, and get ready to publish.
Perfect.
So we continue to make progress.
Thanks. Any questions? All right. Have a good day.
Small enough words.
All right. We're now going in. Commission dates. Commissioners, I think, Christine, did we send everybody the commission dates?
Yes, sir.
Okay.
Chairman, may I jump in? Do you
Yes.
mind? Doug Jennings, General Counsel. We prepared for you in your meeting materials, Commissioners, some proposed dates that we're asking you to adopt. I have been notified of an issue with one of those dates, so with the April 2nd meeting. So what we have for your consideration right now.
What's the issue with April 2nd?
The issue is that on April 2nd, we're going to be having agency, that is the week of our ERT luncheon. When our employees get together, we have a lot of field staff that come in for the week. And there's a training for managers and supervisors that's taking place on Tuesday, and an employee luncheon that is taking place on Thursday.
Okay.
And so I was going to ask you if Friday, April the 5th would work for you instead of the Tuesday the 2nd.
Commissioners, how does that? Oh.
You don't want us to be part of the lunch?
I was gonna say, yeah, that's.
No, the thought was.
That's what I thought I heard publicly too.
Actually,
The thought was, Commissioner Droxram, is that if anyone wanted to come in, of course.
Not now. Why would we want to now?
You'd be fed and happy for the commission meeting, which is our goal.
Butler's got a very good point. Why
Right.
now? Yeah, it's a little late now.
I'm sorry. I thought it was implicit. I thought the invitation was
I think
implicit.
there's a challenge with the 5th, so we're gonna
Okay.
have to pick another date.
We could always move it to the next week,
Yeah.
maybe the Tuesday of the next week.
You want close to the tax day?
So we'll look at the 9th and the 12th. Why don't we send, Christine, can we send those two as an option for the
Yes,
commissioners
sir.
and see how
Okay.
they feel?
Yes.
And then the other slate of meetings that, and we'd ask you to adopt today, just so we have an outline, so we know when to bring rules and time-sensitive matters before you. The other dates would be May 21st, either July 16th or July 23rd, September 10th, October 15th, and December 3rd. And I'm happy to read those again.
No, Mr. Butler will recite them. Go ahead, Mr. Butler.
May 21st, either July 16th or 23rd, September the 10th, October the 15th, December 3rd.
I think, Chair, we got to move through those dates, and if subject to any changes, we can move on.
No, we're waiting on a motion, yes, sir. Yes, we're waiting on a motion, yes.
Okay.
And, so I need a motion on that, and then we'll pending on this April date, for sure.
So
Are you proposing?
Yeah.
Okay. Second?
Second.
All right, all in favor, say aye. Opposed? All right. Motion.
Thank you. So to clarify, we're going to poll the commission on the dates in April and the dates in July. Thank you.
So no lunch, don't worry.
You can show up if you like. All right, executive reports, Mr. Francis.
Mr. Chairman, I'd like to try something new here, a little different. I've asked Heather for licensing and Ron for enforcement to just give a brief 5-minute update. Then I'll have Bruno give a brief update of his other groups under his watch. And then Brandon will provide an update for you on the webpage. And then I'll just say a few comments. But I'd like to try to start bringing some directors into the mix a little bit. They just get so jealous when they don't get to talk to you and sad.
Mr. Francis, last time, Mr. Foster talked and I learned a lot.
Really?
Yeah.
Oh, that is a first. That's outstanding. That's great to hear.
5 minutes.
5 minutes. Okay, where's the clock?
All right, sir, go ahead.
Yes, sir. Good morning. It's great to see y'all. Trying to get some of my documents ready. Thank you. Hey. Good morning, Commissioners. I'm Ron Foster, your Director of Enforcement. It's great to have this opportunity to speak with you again today. Am I speaking loud enough into the microphone?
Pull the mic closer a little
Yeah,
bit.
definitely close.
I'd like to briefly remind y'all about the enforcement process. As you are aware, it can be a long process, as you heard from the cases today that were presented. It's a long process to investigate and prosecute these cases, and it can take months or even years in some cases for that case to go from intake through the investigations process to get it in the hands of a prosecutor and possibly even go to SOA. And that's all before it even gets to you. Right now, we have about 114 employees in enforcement working together to get all of the work done. We primarily receive our cases from consumers that are interacting with our licensees. As you heard during the public comment today about an individual who is having certain experiences with a tow operator. It actually amounts to about 50% of our workload. Then we have about a quarter of our workload, which is the criminal history cases, which tend to make it in front of you for some odd reason, and the internally referred cases that come from other divisions, like our field inspections team or our compliance team, sometimes even education examination and licensing send cases our way. Our intake section is reviewing all of these complaints to determine if we have jurisdiction, to determine whether we can identify the alleged bad actor, and to determine whether that alleged conduct is actually a violation. People complain about all kinds of things. It doesn't mean we can actually act on it. In addition, we are evaluating the complaints that come to us now to prioritize them based upon health and safety risk and whether there was consumer harm. We then assign a priority level to each case as it comes in the door from 1 to 4. 1 is the highest level priority. We focus our attention there. If it's a level 4, we're just closing those cases. We have to do that right now, and I expect for the foreseeable future because it's a lack of resources. We only have so many individuals, and as I'll get into the details a little bit later with the data, we get thousands of cases coming in, so we cannot possibly investigate and prosecute each and every one of those cases. As is appropriate, depending upon the type of a case, it may be assigned after it gets open directly to an investigator or even to a prosecutor. If it's, that typically tends to be the cases that are internal cases, like from field inspections. They go right from our inspections team right to a prosecutor to handle, so we can handle those a little bit quicker. The investigator is performing research, they're obtaining documents, and they're even going on site around the state of Texas to do inspections, to check on those violations that are happening, and to interview witnesses. Afterwards, that investigator is going to complete a full report of what they were observing and what their conclusions were, and they're going to forward that to the prosecutor, who gets to make the final determination on each and every one of our cases. That prosecutor, when they're making their determination, they're going to decide whether or not it's appropriate to issue a warning letter, which happens a lot, or whether we have insufficient evidence. You know, we've investigated that complaint and come up with nothing, and so now we're going to close it. Or they decide if we're going to have to issue a notice of violation and end up going to SOA, to the State Office of Administrative Hearings on that contested case. Those are the ones that come in front of you. The culmination of that process, as you heard, may be a contested case presentation. Every day our team is busy reviewing the complaints and investigating cases and seeking restitution for consumers, and when necessary and appropriate, going to SOA on our cases. I think I'm doing pretty good on the time, right? I have some revealing statistics for you for 2023. This is from January 1st all the way through December 31st. I'd like to share these with you. I'd like you to bear in mind that this is on average with about 110 FTEs in my division. We've had as little as 103 and as many as 115. It's fluctuating every week practically with people coming and going. Our FTE count is cap is 135. We've never gotten to 135. So in the last year, we opened up 12,531 cases. Our intake section, I know Commissioner Drakshaw was asking before about cases that come in that shouldn't be open. We closed 8,128 cases at intake. Those cases did not go to an investigator, they did not go to a prosecutor. We would respond to the person and thank them for filing the complaint and tell them why we couldn't open it, whether it was lack of jurisdiction, lack of respondent, being able to identify the bad person, or whatever the case may be. So division-wide, last year, we closed 19,648 cases. So yes, we have a backlog. We closed more cases than we received, right? Because we're always working a backlog of cases that we have. We had 8,179 investigations that were completed. That's the work of my investigators, how many cases they did. They performed 2,000 cases a lot, and you probably think, man, there's a lot of those. There's so many of them, and we're just denying licenses left and right, and we need to be nice to these people. We reviewed 95,189 applications with a criminal history. That's not the total that the agency received, right? We have a lot of people that renew their licenses every year, so that number is probably more than 200,000. Just the ones that had a criminal history that were referred to my team, 95,189 applications. I have a whole team, awesome team of legal assistants and administrative assistants that are working those applications with the prosecutors to review them. We only opened 2,948 cases based upon the criminal history. We denied or revoked only 148 cases. So out of a percentage just of the total number of people with a criminal history, all the way narrowed down to the number that we actually denied was 0.16%. That's 0.0016. That's 1/5 of 1% of all people with a criminal history. So the people that you see come up here are usually going to be what we would consider the ones where the record is the strongest to indicate denial or revocation of a license, right? Those cases.
30 seconds.
Are you still counting?
There's an overnight.
They seem so engaged and interesting, Brian. I think you're interrupting the flow of what I'm saying.
You're being provided extra 30 seconds.
19 seconds.
I think I'm gonna borrow some time. So from all of those cases, right, that 1/5 of 1% that gets denied, not all those people ask for a hearing, obviously. You heard last year 12 cases. And those were program cases and criminal history cases. Wow. We had default orders, 483 default orders last year. Those are orders where we sent a notice of violation and the person didn't respond to us. They didn't request a hearing, they were like ghosts. And then we had 771 cases where we negotiated an agreed settlement on that case. As you could tell, that's where most of the work is getting done, right? With our default orders and our agreed orders. So right now, I still have some vacancies in enforcement I think you should be aware of. We have an intake section. We have one LA Legal Assistant 2 position. We have 4 investigator positions, one in Dallas, one in Austin, one in Houston, one in Corpus that are available. We have 1 senior legal assistant position that's available. And one of my DPS, what we call DPS, the DPS criminal history team that reviews the criminal history cases. We have one of those positions open, and we have 3 attorney positions, 1 senior attorney position and 1 attorney 3 and 1 attorney 2 position. All of those positions that are still open in my division. All of that work that's getting done. I appreciate the opportunity to provide you an overview. I'd like to express my gratitude and appreciation for your support, and I'd like to open it up to you for untimed amount of questions and answer period as you would like.
I just have a comment.
Yes, ma'am.
It's great work, but I think as much as the great work we're doing, the individual from Dallas that said our investigators or enforcers are cussing them out, doing this, doing that, that's a public relations issue, and I think that really looks bad on us. And I would say we need to find out who it is and hone in on that particular.
I can assure you, if that's even a true statement, because
he
the
drove all
person,
the way from Dallas to,
that person with an injunction that you're talking about has been a very difficult person for us to deal with.
Ron, let's not try
Yes,
to.
I don't want to get into the details of that, but
Tread
I
lightly
can
on that.
assure you that customer service is one of our core values, and we would certainly hold accountable any of our team members that did not display
worth
the
a
utmost
look.
of that. And we absolutely keep track of everything, all of our communications with our team members. We keep track of in our legal case file system, every
Has
phone
he
call,
made a
every
complaint?
email. I could give you a list of all the
Okay,
interactions
that's
we've
fine.
had with this
Okay, your
individual.
point's made.
So,
That-
yes,
that-
it's a very good point, and I
Commissioners
appreciate
wants
it.
to answer the appeal.
Yeah. Thank you.
Real quick, how many conditional or provisional restricted license did we, since the bills passed?
Let me look at, I think I actually have that number somewhere. In the last year, we had 4
Okay.
restricted licenses.
I'm interested because
Now-
when we worked on that bill, you remember that, Brian?
Yes, sir.
Putting that thing together, TPPF. I want to know the metrics of that because the expansion of that is going to be important. So if you can make
Absolutely.
sure and report that metric
Yeah.
back to us because that is a ROI for the state that's
Yeah.
extremely important.
Yeah, and that's extremely important to us because it's a tool in the toolbox, just like what you were talking about today.
Right.
We can have probated suspensions, probated revocations, we can have restricted licenses, and we like to offer that tool when appropriate to the individuals who are working with us. But they have to be able to work with us. As you heard on one of our cases today, you know, we've had struggles trying to get in communication with that person to get what we need so we can get them a restricted license.
Just want to keep track of that.
Yes, sir.
I think it's important. Thank you.
Hear you loud and clear on that.
Any other questions?
Mr. Foster, I think, we've been assessing penalties, but we don't collect much. So what's the recourse, how are we going to handle that one?
Thank you for bringing that up. I had a few statistics I didn't get to talk to you about, and one of them I wanted to talk about. As important as penalties are, we had restitution of $245,916.85 last year. That's money that went back into the pocket of Texans, people that were harmed by or somehow dealt with somebody that was a licensee and didn't feel like they got what they needed out of that. And a lot of times we're able to get refunds and restitution. When it comes to penalties, for fiscal year '23, we did have $568,725, and we collected just a little bit over half of that, with $275,465. It's always been a challenge to collect monies on on some of these classes of, I guess, bad actors. Commissioner Drock showed them, the ones that are unlicensed are the ones that turn into ghosts for us, you know. They can move from city to city. They're in Houston, they're in Dallas, they're all over the place, you know. And we're trying to track them down when we can get a good address, when we can investigate and figure out where they are, what they're doing. We go after them. We work with our general counsel's division to get the debt collector type of people involved in that when it's under 5,000. When it's more than a 5,000 that they owe us, we don't just, ignore that either. We send that over to the Attorney General's office and we work with them to pursue those people. We're not a police agency, so there's limits on what we can do. We can't garnish wages, we can't attach property liens, we can't do things like that. We have to have voluntary compliance in a way.
Chair, if I may, down the line, got to look in like our property taxes, if we don't pay taxes, there is a law firm or something, they collect and they give us the money, but they do the delta, whatever it is they do it. Maybe something on the statute.
Yeah, we're working with somebody, that's basically with the bill collectors, that's what we do. We work with a third party to try to collect those monies, and sometimes they can use a little bit more aggressive tactics, but we don't have a lien, or there's no way we can force people to pay us that money. Other than using the license, we use the license as leverage to get them to pay a lot of times, and that's very effective for people that want to actually do the right thing. Unfortunately, you've got a lot of people out there that don't care. They will continue to do what they do until you get an injunction against them and tell them you're going to get arrested if you don't stop doing that.
Yeah.
So that's what that means when someone says they have an injunction going after them, right? So just be clear.
Any further questions?
You're welcome.
Mr. Chairman, thank you so much. A couple things that Ron talked about with the TBVME. If you notice on your agenda today, that list of dismissals and agreed orders, that is authority that you have delegated to the executive director to sign those on your behalf. At the vet board now, those are currently brought to the commission meeting. So imagine how long your agenda would be if we were actually sending all the agreed orders. That's something that we're going to be working with them on over time to have that authority delegated to their group as well. There was something else Ron said about the inverted pyramid, at 95,000 down to 2,000 cases, and then 148. Yeah, 148. Thank you very much. Mr. Chairman, in that gap between the 2,000 cases that are open and the 148, that is also your metric for the second chance folks. As a person who had a conviction that was tied to our guidelines. And in there, we said, we're still gonna give you a license. So don't just think about the 4 that were issued through the restricted license. That gap between the 2,000 cases that were open and then the difference between, or the delta between the 148 are also folks that our staff has done a diligent job of evaluating and providing those opportunities to those folks. So I want to make sure I put that in your head as something to remember when you think about that delta, okay?
All right. Are you okay?
I am. I
Okay.
think Brian made me sick.
Just off that way. You don't want it.
This back on. You want me to put this back on?
Go ahead. Is that it?
Yes, Heather's gonna go. Ron, thank
Well,
you, great job.
I was prepared to say good morning or good afternoon because I thought Ron was going to talk us into afternoon, but we're still in morning. So good morning, Chairman and Commissioners. My name is Heather Muir, and I am currently serving as the Interim Director of Licensing. And as I thought about what I wanted to talk about today, I remembered my last conversation with Commissioner Droxharam, in which he asked me, how do we know licensing is working? How do we know what you're doing on a daily basis? How do you serve the mission of the agency? And so I thank you for that question because it made me stop and think really all the ways that we do the work that we do and the impact that we have. Obviously, the easy answer is it's seen in the output that we do every day through the issuance of licenses. As you're probably well aware, we regulate currently a little over 900,000 licensees, businesses, and pieces of equipment. So in FY23, there were a little north of 666,000 licenses that were issued or renewed through the licensing division or through our online services that we provide and have available. And of those license holders that we have, about 702,000 are individuals, and the rest of them, the 207,000, fall into those other 2 categories of businesses or equipment. So the chances are pretty high that you each know someone or receive services from someone who is licensed by the department, or that you are impacted daily by the work that we do on my teams. Our main goal is every day to ensure that we are issuing those licenses and renewing those licenses to people who have met the minimum qualifications and are competent to provide those services in the profession that they have chosen to engage in. We have some very hardworking, dedicated people, as those numbers kind of show. But there's also a bunch of ancillary work that we do to support the issuance of a license. And so I wanted to talk to you a little bit about those metrics and those numbers. In licensing, we receive on average 11,000 emails a month that we respond to. This is with the staff of 72 FTEs. And that's a lot. That's a lot of emails and communication that we're having daily with the licensees regarding the laws and the rules, the requirements for the license. Some of those are responses to requests for information that we send out because not all applications are complete. And we do require some interaction between us and them to kind of get that application processed fully through issuance. We have what we call care representatives. Those are customer advocate and research experts that handle escalated cases. These are cases that typically customer service isn't going to be able to see through fully, or the license has been delayed, or there's a little bit more complex issue that's going on. And to date, in fiscal year 24, they've processed almost 5,000 contacts through those 4 care individuals. For FY24, we have reviewed about 490 barbering and cosmetology transcripts. That may or may not lead to a license application, but it's work that has to be done towards that effort that we're doing also every day. And some of those can take up to an hour to review. It's a lot of work. We also do license verifications for our licensees who want to go to another state. And an example of that is that we've done about 300 electrician requests for license verification just this fiscal year alone. But those numbers, we also have a little north of 12,000 things, pieces of mail that had been returned, that have gone out, that have been returned to us because the address, the person has moved. That's also work that we process. That's just this fiscal year as well. And then we have what we call non-money mail, and we've received about 7,500 of those this fiscal year as well. And those, again, are going to be these requests for verification. They're going to be responses to those RFIs that are coming back to us as well. But those are just numbers. That's a little bit about what we do. Where I feel like we make the most impact is on the services that are provided through our license holders that we ensure are competent before we give them their license. So if you have a child or a grandchild that has played a sport, chances are they've received the services of an athletic trainer, been impacted by licensed athletic trainers. We license the barbers and cosmetologists that try really, really hard to make some of us look good. If there are students or individuals who are struggling with communicative disorders or dyslexia, we license the people that provide those vital services to them. We also have safer water, and the integrity of our aquifers are protected because we license the water well drillers and pump installers in this state. I know that I'm getting safer fuel in my vehicle and that I'm getting what I pay for because we regulate FMQ. When people have an unimaginable life-altering event like the loss of a limb, I know that they're going to get support from a licensed, competent, and caring prosthetist whenever they seek those services to get back to what their new normal is in their life. So all of that to say is that that's how we make a difference. That's how you know we're working, because you have those services available to you that are provided safely and competently from the people that we license every day. And so I really appreciate the staff, my staff, and the work that they do every day to make a difference in the lives of people in Texas. And I would also kind of like to talk about some projects that we're working on. We're involved in the new licensing system heavily. We are currently doing a lot of starting to work on mapping our processes to make sure that we're in a good place whenever we do start meeting with the vendor that is selected. We also serve on agency-wide initiatives like bill implementation teams and other things such as, it just flew out of my head. Such as
strategic planning.
Strategic planning, that's what I was gonna say. Yeah, strategic planning sessions, we participate in that. And so we touch a lot of things across the agency as well that we're involved in. Another thing that I'm very proud of is that we have worked really hard to reduce our vacancies. When I started with licensing almost a year ago, we were about a 30% vacancy rate, which is super high. And we've worked really hard, and we've got that down to about 6 fillable positions that are currently open right now. So that's about 8%. And I'm very, very proud of that. And we're working hard to retain those individuals. I'm happy to answer any questions if you have them.
Any questions? Good job on doing the thankless job. We appreciate
Thank
what
you.
do. Thank you
Thank
both.
you.
I know that sometimes it didn't feel like you're back here on the commission, but you are. And we appreciate your efforts on this tremendously. Thank you, Brian.
Mr. Chairman, Commissioners, thank y'all so much. When the team asked me, so what do you want me to report on? It was very simple. What do you want the commissioners to know? And I think you heard that from both Ron and Heather, and I'm very grateful for them being our guinea pigs for today, but y'all did a fantastic job. Next, we'll turn over to Stephen Bruno.
Chairman, if I may say this one, Brian, Mr. Francis, thank you. I think, this is how Texans know that we are working.
I agree.
And thank you for all bringing that up.
Thank you.
Thank you very much.
Really appreciate it.
Thank you. Mr. Bruno.
Yes, sir. Thank you, Mr. Chairman and Commissioners. I'd like to speak a little bit about the other two divisions. Thank you very much, Heather, for that Of course, licensing, one of the divisions I oversee. Steve Bruno, Deputy Executive Director. I'd like to share some statistics from the Customer Service Division. That comprises 51 of our fellow TDLR employees, and I'm so excited as of this month to be having that division under my purview. In December, there were 28,008 contacts answered. That's 25,498 total calls and 2,510 emails. Just a small example of the work that we all do together to get those licenses at the door, or to make sure that the folks in enforcement have what they need to prosecute those cases. So thank you to everyone in customer service for the hard work that you all do every day. I'd like to also talk about our Education and Examination Division and the 16 employees there. Some of the highlights of what we're working on in E&E include updating the jurisprudence exam for the orthotists and prosthetists program. As you all know, we have our state continues to grow. We have people moving here every day from other states and from other countries. Heather alluded to some of that work that's required to make sure that folks who are coming here to Texas to practice their work are qualified. We're conducting an audit on more than 260 driver education provider programs. Driver education and safety, critical for all Texans on the roads every day. So many new drivers, again, so many people moving here, but so many new drivers, and so many drivers who maybe have driven for a while and need some reminders because they've gotten a ticket and they're going to go through a defensive driving program. So part of our job in education and examination is to ensure that those courses that are being provided that are so critical for those who are either learning to drive or need to have some corrective action taken, to make sure those courses are covering the right topics and that they're being delivered effectively and efficiently so that the learning takes place and that actions can be corrected. We've got some statistics here on examination pass rates and the number of examinations administered. It's incredible the amount every month of folks who are coming into a new licensing program, sitting for our exams. They're available throughout the state. We've really made some tremendous efforts to make sure, as compared to the time when I first started here, there were some programs where if you wanted to take a test, you had to come to Austin. And we've been able to expand that so that folks can take tests more easily in other cities, but also in some cases utilizing technology from their homes. You don't have to go to a testing center anymore in some cases. We've got the safety and the capability and the confidence in our systems to ensure that folks can sit and take an exam from the convenience of their home. You hear a lot about exam pass rates. Oh, people aren't passing the exam, therefore the exam must be too hard. That's one myth that I always like to work on correcting. We have exam review committees that work very hard to ensure that a test is psychometrically sound, that those questions being asked, that there's enough questions in the bank for everyone who needs to take tests, and that they're asking the right information in the right way. And we have some exams that are more difficult than others. And you'll find those in those programs. Electrician, for example. If we're going to give you a license to qualify you as a journeyman or a master electrician and all the awesome responsibility that holds, we do want to make sure that that exam is covering what it needs to so that you're minimally competent to serve Texans every day and ensure that equipment's being installed safely. So that's just a little bit of the work. I want to thank, again, every member of the licensing division, the customer service division, and the education and examination division. It's a privilege to get to work with them every day and to say that I am Deputy Executive Director over licensing services, those three divisions that comprise the services we give to our licensees. Thank you.
Great, Steve.
Good job, Steve.
Francis?
Brandy, I think you've got an announcement.
I do, and I'm really excited to tell y'all that. So, first of all, TDLR employees, y'all are just simply incredible for everything that you do every single day. We have a packet of agency staff reports that the commissioners have, but this just doesn't touch all the goodness that you're hearing from all of our different divisions, and you're a part of that. So first and foremost, I want to thank you. I'm going to touch on something that's actually not in your packet, which is a really exciting piece that we have going on. Tila and her team with Josh Schroeder and Todd Rinker have been pouring themselves into a project. And that project is our new website. And it is incredible. We've had the opportunity to kind of preview some of it. It is so clean. It looks so user-friendly. And I wanted to say that these folks did this in-house. There was no vendor procured to put this website together. And the efforts of that team have been going on for over 2 years to put a new website together. So it's an incredible undertaking that they have done, and I applaud them for their work. We're really excited about it, like I said. We're getting ready to roll it out for user testing, and by we, I mean them. Are going to roll it out for user testing this week. And so if everything goes well, fingers crossed, we should be able to go live with the new website on the week of February 26th. So congratulations to Tila and Josh and Todd for all of their hard work putting this together. It's got a great appearance, and it's just stepping up what TDLR does for Texans every day. So thank you.
Thank you very much. And just the brief review that Tila gave on it, it's data-driven. And so they've looked at all the clicks. A person who goes to electrician's page, what are the order of the things that they click on that most likely? And so they've rearranged it to really make it user-friendly. So I'm excited about it. We wanted to tell you, because we know that y'all check the page every day. Don't even worry about it if you think that's weird, but we know you check it every day. And we didn't want you to go out there one day in between the meeting and say, oh my gosh, the page has changed, or this is a new agency. So excited about that. Mr. Chairman, if I could have just a few minutes.
30 seconds, sir.
30 seconds, headgummit. I'm very humbled to be back. And it's been exciting. We, the agency, we've been hitting the ground running towards each other, through each other, with each other. I'm grateful for the reception. I've told them clearly that they didn't stop issuing licenses when I was gone. They didn't stop answering the phone. They've been working hard, and we're just going to continue to work hard together. We have 152 days left to keep doing some stuff, to position this agency to where the next person that sits in this seat will inherit the greatness that this agency is. So 5 priorities in these 152 days. The new licensing system RFP, we want that to be up there and done beyond reproach. I mean, just perfect. And we're on path to do that, so I'm very excited about that. 88th session legislative implementation, we're moving forward with that. The Center of Excellence is a new group. It's new since I came back. They're doing a fantastic job of coordinating the bill implementation, putting that personal touch on things. Strategic planning is upon us, and that's something that I take very personally and near and dear to my heart. So we are in the process of selecting the cities, the locations, and how we're going to move forward with that. Having the huge responsibility of having the vet board attachment. That's not something that we take for granted. That is the legislature recognizing that TDLR can do things right and that we can learn from each other, because we're learning some cool ways from the vet board. It's a back and forth on that. And then the 5th one is just restoring our culture of collaboration, communication, and core values. And the staff will tell you, we've been talking about them regularly since I've been back. And the last thing I'll tell you is that we finished the first iteration of our Deputy Executive Director boot camp. It was Friday morning, a 2.5-hour session, and Louisa Robertson is a jewel. She's amazing. She's in Sharon's department and really helped Yvonne and I put that together for the dads. And they went through their first session, and I was so blown away and proud of how they responded, how vulnerable they were, because it's important in these leadership roles to have that level of vulnerability, to be open to the growth that comes with that type of training. But this little boy, this big boy, is I'm on cloud 9. I'm on cloud 9 being back at the place I love. This is a work of the heart. And I promise you, and hopefully the staff will tell you that I've hit the ground running. I'm studying the rules. I'm looking at the statutes. I'm responding to the calls. It's something that's important to me, and we're gonna just make most of the 152 days we have left to do something great side by side, okay? So thank you for the confidence to bring me back.
Right,
Really
thank you.
appreciate it.
Thank you for that. Thank you for that conversation. Thank you for that effort. Yes, you have any comment? Is that?
I don't know what this 152 days is, so. I just don't agree on, the work continues right there.
We appreciate what you guys have done. Your staff, this agency is amazing in all
Thank you so
respects,
much.
so we appreciate it. Any other comments, commissioners? All right, I think that's it. We got the date set. Take a motion for adjournment.
So moved.
Is there a second? Second. All in favor, say aye. Opposed? All right.